Litigation is the term that's generally applied to legal actions commenced in court and how they're prosecuted and defended. They're driven by procedure, which is dictated by rules. And each court, whether it's the Small Claims Court of New Brunswick, which permits you to bring certain claims for up to $20,000, or the Court of Queen's Bench, which has jurisdiction over all other types of claims, and certainly all claims in excess of $20,000. The rules of these courts dictate the process that you may have to pursue before you obtain a remedy or settlement of your case. To help you understand, the processes are basically broken down in several stages or steps. The first stage or step is the initiation of the court proceeding by the filing of a claim or an action. The action or the claim set out certain allegations of fact, but not necessarily the evidence as to how those facts will be proven, which, if accepted as proven by the court, would entitle you to a legal remedy. Typically, claims that have been commenced and filed and defended will then proceed on to a stage of mutual disclosure by the parties of documents relevant to the issues in the case, sometimes in the Court of Queen's Bench, followed by something known as examination for discovery, or depositions, as they're sometimes referred to. If you add that word in a YouTube search, you'll find examples of what those pre-trial hearings consist of. The purpose of a examination for discovery or a deposition is, in the absence of the court, the parties will obtain the evidence under oath or affirmation of each of the parties in support of the alleged facts, which they believe either entitle them to a remedy or which they believe entitle them to a defense to the claims brought against them in the case. Many cases after an examination for discovery or deposition will settle because each party has committed themselves to certain answers to certain questions about the critical facts in the case needed to be proven, either by way of proving or defending the claim, which cannot readily be taken back at a final hearing in the form of a trial without loss of credibility. Many cases after depositions or examination for discovery will proceed on to a negotiated settlement, because it is apparent to both parties what the relative strengths and weaknesses are of their cases after a discovery. There is a simplified procedure under Rule 79 in the Court of Queen's Bench which dispenses with the pre-trial procedure or deposition stage of the case. Instead, a series of affidavits, which are sometimes referred to as will say affidavits, as in this is what certain witnesses will say at an eventual trial, in substitution for the pretrial examination or deposition process. This is for claims that are less than $75,000 in value. It is sometimes referred to as a simplified procedure, and it is governed by Rule 79 under the Court of Queen's Bench Rules of Court. If you are contemplating or are in the process of being involved in a civil suit in the courts, it's incumbent to get professional advice as soon as possible, especially after initially receiving documents. In many cases where you may have insurance that covers you as a defendant, it's imperative that you advise your insurance company promptly if you have been served with court documents that have commenced the legal proceeding against you. It is not unusual for court cases to take a significant period of time to advance to the stage where the case may be ready for trial or serious negotiated settlement. There are pretrial procedures which are designed to enhance the possibility of settlement, including cases which have been scheduled for trial for 2 days or more. It is mandatory that the parties attend a pretrial settlement conference with a judge other than the judge assigned to hear the case on a final basis, who will attempt to assist the parties and their counsel in negotiating a settlement. Many settlement conferences are highly effective in assisting the parties in resolving cases, both in the family division as well as in the trial division for civil cases, and are often a key tool in helping parties get cases resolved. The vast majority of cases never proceed to trial. They are typically settled out of court. through such mechanisms as mediation is resolved. The vast majority of cases never proceed to trial. They are typically settled out of court through such mechanisms as mediation and pretrial settlement conference. I hope this video was of some assistance and interest to you on the subject of civil litigation.